Good morning. Today's daf is Sanhedrin daf Gimel. Yesterday we got a chance to start Masechet Sanhedrin, and we are going to continue with the second daf today. I'm going to share my screen, and we'll be able to get started. Yesterday we concluded by explaining that the Mishnah references both monetary cases and robbery and wounding in order to teach that the Mishnah's details apply specifically to the monetary cases of robbery and wounding, but not to the monetary cases of admission and loans. So if I were to admit something that would that I owe you something, or if I loan you money and have witnesses, that would not be the same rules as the ones associated with robbery and wounding. However, if we say that our Mishnah doesn't apply, what rules do apply to the cases of admission and loans? And so that's what we're going to pick up with. Now, it's important to remember, I didn't note it in the introduction on the screen, but it's important to remember that this is the answer of Rabbi Abahu to the question of why are we mentioning Gezelos and Chavalos separately from Dine Mamanos, meaning once we say Dine Mamanos, that certainly includes Gzelos and Chavalos. Dine Mamanos meaning monetary cases, and Gzelos and Chavalos meaning cases of robbery and cases of wounding. So why wouldn't those already be included? And so again, he's answering that actually they are the specific cases within the category of monetary that are being dealt with. And there are other cases, namely admission and loans, that don't have the rules that are detailed in our Mishnah. And so as a result, as we pick up on the 11th line, at the beginning of the 11th line from the bottom of Bet Amud Bet, so the Gemara is going to attempt to address that question. So ulamai, so what is what's the purpose of the exclusion of admissions and loans? Ilema delo be'inan shlosha. Maybe you want to say, well, those cases, maybe they don't need three. After all, the core element of our Mishnah is to say that all of the cases in the first cases in the Mishnah all involve three judges. But Rabbi Abahu himself says, Shnayim shedanu dine mamanos, that if two judges judge a case in a monetary case, l'divrei hakol ein dine dinan. Everybody agrees that their judgment isn't a valid judgment. Ella deloba inan mumchin. So as a result, Ella deloba inan mumchin. So the answer is that no, what it's got to be is that we are talking about a situation where we don't need expert judges. We don't need judges that have been ordained. And so as a result, as Rashi puts it, mumchin, it's the Rashi at the bottom of the Rashi in the wider lines of the bottom of the Rashi. It's 8 lines down. First word on the line, mumchin, smuchin, meaning they have smicha, v'natlu rishus minasi, and they got permission from the head of the Jewish community, ledun, in order to judge, k'da'amrin l'kamam b'pirkin, as we will see in a couple of days, by the end of the weekend, or by Monday, God willing, we'll have seen this detail. I guess Sunday, I think, is Daf Hey. So as a result, that's the potential answer. So my kasabar. So 1 second. So what does our Tana hold that, why is it that he would reach these different conclusions with respect to what kind of judges are required? So kasavar erev parshios ksuv kan liboy nami mumchin. So because we have a problem. The problem is that if in fact the our Tana says that the discussion in the Torah, when you have a topic that is discussed somewhere else and you have a mixture of two discussions, that you need to connect all of the issues together, well then libay nami mumchin. Well, the issue is that we have psukim here that specifically in Shmot Perek Kaf Bet Pasuk Chet, we have which teaches both about the oath of a partial admission and the rule associated with an unpaid watcher, that both of them are being discussed in the same concept. So let's take a look in Rashi. We can see Rashi. Rashi goes through it for us. Ikasaver erev parshios ksiv kan. If we think that there's a mixture of topics that are discussed here, de'ikalaman to amar ba gozel eitzim, that we'll see, that we saw in Hagozel Eitzim back in Baba Kama Daf Kuf Zayin Amud Aleph Shab Parshiot Ketuvot Be'ela Mishpatim, that some of the discussions in Parshas Mishpatim Me'ur Bavot Hein, they have a mixture of things. Sheyesh Mikra Katuv Be'Parsha Zu She'ena Yachol La'amod Ba, because there are aspects of certain discussions that clearly aren't referring to the context in which they're written, Ela Mefarsha Ab Miparsha Acheret Hu, but rather are touching on a topic that's separate. Kagon Asher Yomar Kihuzeh. For example, when the Torah says Perakav Bet Pasuk Chet Kihuzeh, and this was the pasuk that Ken mentioned yesterday as being in his Dvar Torah, the Yalfina Mine Moda B'Miktsas Hataina Yishava, that we learn from that pasuk Ki Huzeh, where it says the fact that he's going to that this is what I am watching of yours. Then that's effectively saying I'm not watching anything else, and that is effectively some sort of moda b'miktzas. And you learn from that a moda b'miktzas swears just like somebody who watches something swears if they deny having it. Shekasav b'shomer chinam, which is written again in that pasuk in Perakav Bet, pasuk Chet, is written in the context of an unpaid watcher. Lava shomer chinam kai. That concept of moda b'miktzas does not in fact apply to an unpaid watcher. To shomrin, because when it comes to watchers, afal pi shelo hodu b'miktzas, even when they don't admit partially to having had something to watch. So if I say to you that I gave you 3 watches to watch, and you say, no, you only gave me 1 watch to watch, that you would still have to swear. But the point is, even if you say you gave me no watches to watch, you would have to swear the oath of a watcher, because I gave them to you to watch. So chayvinan lishavad, you would have to swear. Dehodam mixes hataina a parshas deim kesef tilvekai, because the only situation where a moda b'miktzas is where you swear, and when you deny the whole thing, you don't have to swear, is where you borrow the money. That only when there's a borrowing do you have to admit to partially having taken some of the money in order for there to be a moda b'miktzas that triggers an oath. But when it comes to a watcher, even if he denies the whole thing, will need to swear. The lo moda klum, but if you don't admit anything when it comes to a load, chazaka im tainas hatoveya ms. Lod haya yachol zeh laha'is panav, that we have this principle, we have a chazaka effectively, that we say that if in fact there was any truth to the claim of the claimant, then the denier would never be able to be so obnoxious as to deny the whole thing negdo, right in front of him. So velomar lo hilvesani, I didn't borrow anything. Hilkach afilu shvuah lo bai, and as a result, even an oath is not required in that situation. However, aval b'pikadon, when it comes to something that is being laid with you to watch, deleka gemilos chasadim, where there is no kindness. In fact, it's you that's been kind in watching the thing for somebody else. So meiz panav, people do get that obnoxious. V'kofar hakol, and they will deny the entire thing. Ubai shvua, and therefore, even in a kofar hakol situation, you'll need to swear. V'hai tana demasnisin, and so now what are we talking about? So again, we have this concept that the same psukim can be talking about 2 different topics. So when our Mishnah is dealing with this issue, isvirule nami dahai asher yomar kihuzeh behalva mishtoi hari nemar Elohim bahai kra. Well, 1 second. That pasuk also is the one that references Elohim as the judges. And so Idemashma mumchin, that's the language. Elohim as the reference to judges as opposed to shoftim suggests a level of expertise. lashon srara, some kind of rulership, v'rabbanut, and education and knowledge of the Torah. Kedema targaminan rana titicha Elohim leparo. Right? See, I've made you an Elohim for Paro, which we'll have near the beginning of Sefer Shmos, Lashon Rabbanut, that it's a language of sort of overseeing and a requirement of expertise. And so what Rashi is telling us is that if, in fact, the person who's the author of our Mishnah says that these two topics are being discussed in this pasuk chet in Perek in Perek Bet of Sefer Shmod, well, then it must be that the whatever rule applies to a monetary case, to a case of a loan and admission, would also apply to a case of a watcher. And so as a result, just as a watcher requires an Elohim, an expert judge, a judge that's been ordained, so too will end up saying that a loan would also require an ordained judge. V'ikasavar, and now back into the Gemara, and we're 1, 2, 3, 4, 5, 6, 7, 1, 2, 3, 4, 5, 6. The last word on the seventh line from the bottom of Beis Hamabez. The ikasavar ein eruv parshios ksuvkan, and if you say that there's no mixture of psukim, so this pasuk is only talking about unpaid watchers, well then shlosh lamali. What's the basis for requiring 3 judges at all in connection with loans and admissions? So that's the question that the Gemara asks, meaning either you should go all the way and say that you also require expert judges, or you should go all the way in the other direction and say that you shouldn't even require 3 judges. So la'olam kasavar erev parshios ksuvkan. Really, the Tana of our Mishnah thinks that actually we do mix the topics, and that both topics are being discussed in this pasuk, and therefore you do need 3 judges for loan cases. Ubidinhu dilibai nami mumkin. And really, the law should be that we require 3 expert judges. V'hai deloba einan min mumkin. And why is it that we don't require expert judges, that we don't require ordained judges? Mishum de Rabbi Chanina. It's because of the statement by Rabbi Chanina. Why? What did Rabbi Chanina say? Da'amar Rabbi Chanina, Dvar Torah, echadine mamonos ve'echadine nefashos b'drisha v'chakira. When it comes to the biblical law, you would say that when it comes to both capital cases and with respect to monetary cases, you would need a full-fledged investigation, drisha v'chakira. Let's take a look in Rashi, last Rashi on the page. Tzarech livdok es ha'edim. You need to check out the witnesses really well. Be'eza yom, what day did it happen? Be'ezo shah helvahu, at what time did he borrow the money? So you would need to do that kind of detailed analysis, and the result would be that sometimes the witnesses in a loan situation might get confused and might not know exactly what the right time is, and might be inconsistent, and therefore there won't be a finding of liability. Shene'amar mishpat echad yiyelechem, because after all, the Torah says that you should have one law, meaning that the law of capital cases and monetary cases should be the same. Umatam amru dine mamos lo be'inan drisha v'chakira. So why is it that the rabbi said we don't want to require that level of investigation and questioning of witnesses in monetary cases? Because we don't want to close the door in face of borrowers, right? Take a look in Rashi, 3rd line down in the Rashi on Gimel Amud Aleph, as we're now on Gimel Amud Aleph. Shalotin al delis sheyimneu milahavot. If we're going to, when we say close the doors, we mean that people will refuse to loan money. Shema yichfor. Maybe the person will deny it. V'ha'edim yit'u. And yes, he had witnesses, but they'll make a mistake. V'lo tehei edusan mekuvenes. Their testimony won't align. V'yafsid, and he'll end up losing his money. V'hachanami, and here too, when it comes to the question of using expert judges, shemelo yimatze mumchin, maybe he won't be able to find three expert ordained judges, lekofo badin, in order to force him into judgment. And so as a result, that's why the person's not going to make loans. Right. After all, if I make a loan to Stan and I have witnesses, I expect to get paid back. And if I think that there's going to be an increased risk of me not getting paid back, well, then I'm not going to loan money. And we need those loans. Those loans are crucial to the survival of the Jewish people because people were struggling and they needed to be able to borrow money in order to survive. Ella. So in second, once you're telling me now that in fact these non-expert judges effectively have the qualification, we're treating them like expert judges because we're trying to be so generous to them. Well, elamiata tov lo yishalmu. Well, in second, why not let them, if they make a mistake, when it comes to expert judges, if they make a mistake, we say, no, well, they're an expert judge. It was clearly an accident. We're not going to hold them liable for a mistake in ruling. But if, in fact, they're not ordained judges, then when they make a mistake, they do have to pay. But why do we make them pay? We should actually allow them not to pay, just like expert judges, as Rashi says, top of the narrow lines in Rashi, Elamiata tau hedyotot b'dine mamonot. If the regular judges make a mistake in the regular people who are sitting as judges make a mistake in some kind of monetary matter, lo yishalmu, let them not have to pay. Dekevin debershus rabbanan kanachti, because after all they're sitting with the permission of the rabbis. Habalahu kamumchin, they should be treated just like expert judges. Meaning, if the rabbis go out of their way to say that any Joe Schmo can sit as a judge, well, then what they're effectively saying is a Joe Schmo is equivalent to an expert. And an expert doesn't have to pay damages if they make a mistake. So too, Joe Schmo shouldn't. V'chol hamumcha lebeis im tau pater, and any expert, any ordained judge who sits on a beis din, if he makes a mistake, is exempt milashalim from paying. Kedila kaman, as we're going to see in several weeks, be'echad dine mamos, in the chapter echad dine mamonos, hasha eno mumcha chayev, and we're going to see that only those who are not experts are obligated. So why do we hold these non or experts as being liable? Well, 1 second. Remember now back to the perspective of the lender, that if the lender knows that if his judges make a mistake, that they won't be held liable, well, now he's going to once again maybe refuse to lend money, because now there's no protections for him. In fact, he has a great case, right? The point is that if in fact when the non-experts are judging and if they make a mistake, they'll be liable. Well, then that's great protection because that'll make sure that they don't make any mistakes. Okay.
Or he just raises the ante, so to speak.
Yeah, 100%. So okay, so now we've gotten through that. But ihachi, if you're going to tell me all of this, and now you've given all of this, has been all an effort to explain why our Mishnah begins by saying, let's go to the beginning, right? Dine mamonos b'shlosha, that you judge monetary matters with 3, and gzelos v'chavalos b'shlosha, and we deal with robbery and wounds with 3 as well. So that's the reason that we did that, is because we needed to teach all of this. All of that, all of what we've just covered has been amazingly captured by those 6 words in our Mishnah. But if that's true, Tarti Katani, so Dine Mamanos, why not teach it the following? Dine Mamanos B'shlosha Hedyotot, Gzelos V'chavalos B'shlosha Mumchin. Why not teach it the following? That when you have monetary matters, you learn it with, they're judged with 3 lay people, meaning non-ordained, 3 regular people, but Gzelos V'chavalos, but robbery and wounds, they're dealt with by 3 experts, by 3 ordained judges. V'od shlosha shlosha lamali. Moreover, you told us, Rabbi Abahu, that when we said dine mamonos b'shlosha gzelos v'chavolos b'shlosha, what we were really saying is dine mamonos. What are dine mamonos? That we're talking about gzelos v'chavolos. Well, why did you need to insert the word b'shlosha there? You should have just said dine mamonos gzelos v'chavolos b'shlosha. That would then I would really understand that what are dine mamonos? It is gzelos v'chavalos. So once we're going to have an extra word, so to speak, and add in that extra shlosha, so then we should add in the word that it's saying that it's hedyotos, and we'd be even clearer. So there doesn't make any sense to explain it the way Rabbi Abahu explained it. So Rava offers now, so as a result, the Gemara has effectively rejected Rabbi Abahu's approach, and Rava offers just a slight modification of it. And so what he's saying is, Amar Ella Amar Rava Tartik Tani. Really, we are learning two separate cases. Mishum de Rabbi Chanina. But the point is still the same point. It's the point that Rabbi Chanina made. Namely, we have to be careful about closing the door in front of borrowers by making it too hard for the lender to collect. So that's possibility number two. And here we have, let's take a look at Rashi, Tartik Tani. It's 1, 2, 3. From the bottom of the narrow lines in the Rashi, it's about 14 lines up in the Rashi. Tartik Tani, we're learning two separate cases. Devadai Gimel Binan. There's no question that we need three judges. De'eru Parshios Ksiv Kan. Because there are two different topics that were written about in Parakuf Bet Pasuk Chet of Shmot, and therefore we're going to learn both about the fact that you need three expert judges in a connection with a case of watchers, and you need three judges in a case of borrowers. Thank you. And umiu behed yoto sagi, but nonetheless, when it comes to the borrowing, then the regular people are sufficient. Why? Mishum de Rabbi Chanina, because Rabbi Chanina's point, meaning we don't want to close the door in front of borrowers. And if we said that in fact borrowers weren't going to be able to collect without going to expert judges, it'll be too difficult for them. V'haki kamar, and so this is what we're saying. Dine mamanos, dahainu, hodaos, vilhavaos, that when it comes to monetary matters which constitute the admissions and loans, bishlosha hedyotot, that requires three hedyotot. Ugzelot, the chavalos, bishlosha mumchin, and when it comes to stealing, to robbery, and to wounding, then you need three experts. And that's really what the Mishnah is teaching us. So that's answer number two. So that's explanation number two. And now we come to explanation number three. Explanation number three is offered by Rav Acha. Rav Acha Brei de Rav Ika Amar Midoraisa Chad Nami Kasher. He goes in the opposite direction. He says, you know what? Really, only one judge is really required for monetary matters. Shenemar B'tzedek Tishbot Amitecha. Right? It says. This is a pasuk in Vayikra Parak Yud Tet, pasuk Tezvav, that it says that you should, with justice shall you judge your fellow, meaning a judge suggesting singularly, Elamishum Yoshve Kranos, but we have a concern, because, and not only is it one judge, but one judge even that's not an expert, but we have a concern because maybe those experts are really not too knowledgeable. So let's take a look. Rashi, Oraisa Chad Nami Kasher. It's 1, 2, 3, 7 lines up from the end of the narrow lines in Rashi. Midoraisa Chad Nami Kasher. Really, one is sufficient. Vahoda v'halba when it comes to admissions and loans. Diksiv Tishbot Lashon Yachid, because the wording of that pasuk, B'tzedek Tishbot Amitecha, that with justice you shall judge your friend, your fellow. That judging, that judging is in singular form. It doesn't say tishpotu, it's you singular. So that suggests that one judge should be sufficient in certain cases. Ve'ein eru parshios kan, and as a result, we're going to say that there is no mixture of psukim when it comes to Shmot, Parakaf, Bet, Pasuk, Chet. That it's only talking about the watchers. And therefore, when it comes to watchers, you need three experts. But when it comes to other matter, when it comes to loans and admissions, one judge is sufficient. Umas nisin, and when it comes to our Mishnah, vade tarti katani, it is certainly teaching us two separate rules. Kida amran, as we just said, because after all, that's why it says shlosha twice. So what is it saying? It's not telling me what kind of monetary cases there are, but it's saying monetary cases, namely loans and admissions. You need three judges, but you need umiyu shlosha behodos valvos lavmedo raisa elamidurabanan. But when you say that we need three judges there, it's not biblically three judges, it's rabbinically three judges. So, and they don't need to be experts. So that's what he's saying. And what do we mean by Gzeira Mishum Yoshvei Karanos? That's the next Rashi. Gzeira Mishum Yoshvei Karanos. Tagrin, these could be merchants, she'ein bekiyin b'tiv dinin. They don't know well the law. And what will end up happening? They'll accidentally go for the wrong guy. And so as a result, in order to limit the risk of that, let's require three. Because if you require three, somebody in there is going to be knowledgeable enough to be okay.
With all the judges for these different cases, do they have to be unanimous in decision?
Great question. We're going to get to there very, very shortly. Okay. The answer to your question is no, but we're going to actually see that it could be a potential area of dispute, but I'm not sure whether that's today or tomorrow. But let's take a but the answer to your question, the simple question is no. And that's true even in death penalty cases, unlike in the U.S. judicial system where you need unanimity in most criminal cases. So then that is not the case here. Okay, so now that we've explained according to Rav Acha that we're worried about unknowledgeable non-experts, non-ordained judges. Atu bitlasa milo havi yoshve karanos. Well, one second. If the probability of the average guy is that he's going to be a yoshvei kranos, a corner sitter, that's the definition. That's what it literally means. But we mean somebody who's not too knowledgeable, meaning who doesn't get out there in the world and therefore doesn't have the experience necessary. Well, whatever that probability is, that means that there's a probability that all three of them will be not so knowledgeable. So the Gemara answers, it's impossible that at least one of them won't be knowledgeable. As Rashi continues, the top of the wide lines in the Rashi at the bottom, that he'll have heard something from those who do have knowledge, and he'll know how to judge properly a case. So, so, all right. So once again, if in fact they will have gotten some expertise, why are we making non-mumchin judges liable for making a mistake? So again, kol shekain denefisha yoshvei kranos. Well, if you don't make them liable for making mistakes, well, then those judges will have no incentive to be anything other than a corner sitter. The way we get them to get some knowledge is by telling them if they make a mistake, we're going to make them liable. So now what's the difference between these two approaches, right? We have now two valid approaches that work completely, right? We have Rava's approach that our Mishnah, that really you require three judges biblically in both cases. And it's because we're trying to be lenient based on Rabbi Chanina that we're going to allow three non-expert judges in loan cases and admission cases. But Rav Acha came at it the other direction. Really, in loan and admission cases, you only need one judge, but we're worried about one non-expert judge that he'll make a mistake mistake and he won't be knowledgeable of the law. So what we'll do is we're going to require 3 judges even in that situation as well. So my Ika being Rava l'Rav Acha Brei de Rav Ika. So what's the difference between those two situations? Well, how do I tell that there's what, from a practical standpoint, what's the case that might show different answers? What Shmuel said would be the difference. Shnayim shedanu dinei hindin. That Shmuel says that if 2 judges reach a decision in their judgment, that is a valid decision. Elishanikra based in chatzuf, but they're called an insolent court. As Rashi says, why are they called a chatzuf? A beit din chatzuf. It's 1, 2, 3, 5 lines down in the Rashi in the wide lines at the bottom of Gimel and Aleph. Beit din chatzuf she'avru al takanas chachamim, because they violated the rule that the chachamim said that you need to have 3 judges. So li Rav Acha Brei de Rav Ika Islay de Shmuel. According to li Rava, I skipped. Li Rava Leislay de Shmuel. According to Rava, he does not agree with Shmuel because he says that the requirement for 3 judges is biblical. And so therefore, you can't get away with 2 judges. But Rav Acha Brei de Rav Ika, but according to Rav Acha Brei de Rav Ika, it's fine to have 2 judges because really all you need is 1 judge. And so therefore, he would agree with Shmuel's statement. Okay, so let's take a look at those 2 statements. L'Rava, that's 1, 2, 1. The comment on Rava is actually before the based in chatzuf. It's on the 4th line of the wide lines at the bottom of Rashi. The Rava da'amr b'doraisa tlasabinan. As I said, the Rashi points out that this is where I got it from. That according to Rava, you need 3 judges biblically So leis lay to Shmuel. So he doesn't hold of Shmuel at all. Da'amr dinei and din, because Shmuel says that 2 is sufficient for their judgment to be valid. Okay, so that is the end result, that we have the discussion of these various approaches, and we've now concluded with this discussion. And we had 3 different approaches to how to understand those first 6 words. The second 2 of those approaches ended up being okay, and we now clarified what would be the difference between those 2 different approaches. Okay, so now it does not seem like we paskin like Shmuel. So I think that we would say like Rava that through 3 judges is biblically, that we do in fact say that you combine the 2 issues, and therefore just as 3 judges are required biblically for cases of watchers, 3 judges are required biblically for cases of loans and admissions. Okay, so now we go on to the next wording, and the Gemara turns to the discussion of the damages and half damages from our Mishnah, where it said nezek v'chatzi nezek. So nezek hainu chavalos. Well, 1 second. Nezek is the same thing as injury, meaning when you injure somebody, you're obligated to pay the 5 different kinds of payments, and one of them is called nezek. So hainu nezek, hainu chavalos. Take a look in Rashi, 1, 2, 3, 6 lines down in Rashi. My kari nezek, umay kari chavalos. What do you mean when you say nezek, and what do you mean when you say chavalos? Because hanezek echad mechamisha dvarim shel chavalosu. Because usually nezek is one of the 5 different methods of paying for a wound. V'leisnei chavalos lo by nezek. And so, if you don't have a chavala, you don't have nezek. Meaning the point is that why do you need to reference nezek here at all? So mishum de kabai lemisne chatzi nezek. Well, once we're talking about chatzi nezek, so that's why we're going to have the reference, the full nezek. And again, remember that chatzi nezek is a situation where you have an ox of yours that is a tam ox that is not gored 3 times, and as a result, you're only going to be subject to half damages. So because we referenced half damages, we also wanted to mention full damage. Tani nami nezek shalim. So we also mentioned full damages. Well, 1 second, chatzi nezek nami hainu chavalos. But but half damages is also a kind of bodily injury because tana mamona, tana. So sorry, that's the answer. So the point being that we saw yesterday the concept that effectively, when you have monetary situations, bodily injury, that's also covered by certain kinds of physical injury to your property. So tana mamona, tana kanasa. No, the point is that when it comes to mamona, that we want to learn that as one category, that's compensation, and the tana kanasa, and also we need to talk about penalties. At least according to some opinions, the 50% damages is a penalty that really we shouldn't, that somebody who owns a tom ox should not be liable at all for the damages that ox causes by goring somebody else's ox because it was not known to be a goring ox. But because of a penalty, we're going to make them liable. So Hanichalamanda Amar Palganizka Kanasa. That works well according to the person who says that 50% when you pay half the damages, it's a penalty. Elamanda Amar Palganizka Mamona Ma'ikalamemar. But there's another viewpoint that we learned back when we learned about full damages and half damages. And that's the viewpoint of that says that actually you should be liable 100% for your animal's goring. But because that animal had never gored before, we're going to be lenient on you and say you only have to pay half. Well, according to that view, that's not a penalty. That's actually a release. You're doing compensation when you pay the 50%. So Ella ID de kaboy lemisne tashlumi kefel b'tashlumi arba v'chamisha demamon, that when it comes to 2 times and 4 times, which is demamon she'eno mishtalim biroshu, which is an amount of money that is not the specific principal amount, as Rashi tells us. She'eno, top of the, as we turn to Gimel Amabet, turn to the top of Rashi on Gimel Amabet, She'eno mishtalem birosh, shemishalem yoter min keren, right? When you pay double or 4 times or 5 times, that's more than 100%. That v'chatzi nezek, and when you pay 50%, mishalim pachad min keren, you're paying less than 100%. Birosh. Birosh. Hainu Karen, and when we say the word rosh here, we mean the principal, the original amount. Diksiv v'shilem oto birosho, because it says in Vayikra Parakeh that he'll pay him the amount, the original amount. So it's there, that pasuk is talking about the principal amount, and so too when we say birosh here too we mean the principal amount. So the point is that why are we learning the requirement to pay full damages? Because we're already going to be talking about situations where you don't pay the exact 100% of the amount of the damages. So once we do that, so we're going to also talk about the other. So Taneinami. So once we talk about the case of double and 4 or 5 times damages, as we pick up on the top line of Gimel Amud Bet, Tananami chatzi nezek demamon she'enu mishtalim biroshu. So we'll also teach about half damages, which also is not equal to the original amount. V'aidi de kaboy lemisnei chatzi nezek. And once we teach about half damages, Tainami nezek. So now we're also going to teach full damages. So the point is that you're absolutely right that we did not need to mention nezek in our Mishnah, but we mentioned nezek in our Mishnah because we also talked about chatzi nezek. Okay, so now we turn to the next topic, and the next topic is how do we know that we need a minimum of 3 judges? Now, we've seen this indirectly in the Rashi yesterday, and we're now going to see it directly in the Gemara. So, Shlosha Minalan, how do I know that we need 3 judges? The Tana Rabbanan, V'nikrav Bal Habayit El HaElohim, that the person, the master of the house, the homeowner, will go to the judge. Hare kan echad. That's 1 judge. Now the next pasuk says, Ada Elohim Yavo, Dvar Shnehem, that to the judge will come the matter of the 2 of them. So that's a second judge. Hare kan shnayim. Now that's the second judge. Asher yarshion Elohim. And who's going to win? And who's going to lose, right? Whoever the judge says is the Russia and condemns, that's the person who's going to lose. Hare kan shlosha. So we have three references to Elohim. Again, that Elohim is not the God's name. It's a reference to judges, and so that's why you can use the hey. And the point is that divrei Rabbi Yoshia. That's Rabbi Yoshia's viewpoint. So now we've explained how we get to three judges. Rabbi Yonasan Omer. Rabbi Yonasan says Rishon Tchila Nemar. Well, look, the first time we mention a judge, it is to tell us what we're talking about. Because according to Rabbi Yonatan, you can't learn from the first time something is referenced in the Torah. You need a baseline to understand what you're talking about. Then you can say that the repetition, the second and the third, the Ein Darshan Tchilos, we don't learn from the initial description. Ella Ad Elohim Yavo Devar Shnehem. So we have the second, in the second verse, it says to the judge will come the matter of the two of them. Hare kan echad. Asher Yarshion Elohim. And then we say that whoever the judge condemns, Hare kan shnayim. And that gets us to two judges. Now, how do we get to the third judge? The ain based in shakel. We don't have an even number of judges. This is what we talked about at the beginning of yesterday, where we said, hey, what about the 10 judges? Because Ken was exactly right. And we will see in a couple of weeks that actually the 10 judges, like the reference here, is based on the number of times a word is said in a pasuk. And so it's a direct, essentially a xeris hakasuv that we learn out those 10 judges. So too, but in any event, what about ein beitun shakel? So as a result, we don't have an even court. So therefore, Mosif and Alein Odechad will add a third judge, Hare kan shlosha. So therefore, we have three judges. So Nema Bedorshin Tchilos Kamiflagi, should we say that the machlokas between Rabbi Yoshia and Rabbi Yonatan is whether or not we learn from the first case of the first description? Demar Savar Dorshan Tchilos. So Rabbi Yoshia says we do. Umar Savar Ein Dorshan Tchilos, and your Rabbi Yonatan says we don't. No, you don't have to say that. Really, you could say Dekuliyama Ein Dorshan Tchilos. Really, everybody agrees you don't. And Amar Lach Rabbi Yoshia, and Rabbi Yoshia would tell you, Im Kain, if you really wanted to say, why is it that I am learning from the first reference to Elohim? I'm learning from it because Nemakra v'nikrav balabayas el hashofet. My Eloha Elohim, Shma mina leminyana. So really, it should have said the judge. Using the word shofet. Why did it use the expertise level judge of Elohim? It must be in order to allow us to count that as towards the number. Rabbi Yonatan lishna de alma nakat. And why doesn't Rabbi Yonatan agree with Rabbi Yoshia's explanation and say that we should learn from the fact that it doesn't say shofet, but instead says Elohim, because lishna de alma nakat, that is language of Elohim is a commonly used language. As people would say, man de isle dina likrav legabi dayana. Meaning that people use colloquialisms, and the colloquialism that the Torah was using of Elohim is not something that you could really derive anything from. As Rashi explains, take a look at Rashi. Legabi Diana, Eitzel Dayan Hirgil Velo Eitzel Hedyot, meaning that you should be that the idea is of this phrase of Isle Dina Likrav Lagabi Dayana, that we go to a Dayan that is an expert, or somebody who is knowledgeable, and not to a plain guy. And so as a result, the Torah's reference to Elohim is not so surprising. It's telling us that we go to an expert. And so it's not able to teach us the fact that we are supposed to count that reference to Elohim as one of the three judges. So for Rabbi Yoshia, Leisle based in Nota, well, 1 second, that may suggest that Rabbi Yoshia, who counts the three judges based on the reference to the number of Elohims, does that mean that Rabbi Yoshia is okay with an even court? V'hatanya, Rabbi Eliezer ben Noshel, Rabbi Yosia Glili Omer, Ma Talmud Lomar lintos acharei l'rabim lahatos. What do I learn from the pasuk that says that we go and we decide after the majority? Torah Amra aseh lecha based in nota, that we should always be able to have a majority in a court. You can't have it be an even number of judges, because if you have an even number of judges, you can have a tie. So Savar La, Rabbi Yehuda, de Amar Shivim. No, Rabbi Yoshia doesn't necessarily have to agree with that. So right now, our question on Rabbi Yoshia is maybe he, how could he not agree that you have to have an odd number of judges? It's clear that Rabbi Yoshia Glili, Rabbi Eliezer, the son of Rabbi Yoshia Glili, tells us that you have to have an odd number of judges. So not necessarily, because Rabbi Yoshia could agree that, like Rabbi Yehuda, Savar like Rabbi Yehuda, the Amar Shivim. Remember, in our Mishnah, as we're about to read, Tanan, in our Mishnah, we said Sanhedrin Gedola Haisa Shel Shivim ve'echad. That the Tanakama said you need 71. Rabbi Yehuda Omer Shivim, but Rabbi Yehuda said 70. You can have an even number of judges. Indeed, our Sanhedrin, the top court of the land, had 70 judges. Amar Deshamat Le Rabbi Yehuda, but even second, have bid Sanhedrin Gedola Dixive Cry. The only time I know where I've heard Rabbi Yehuda say you can have an even number of judges is when it came to the Sanhedrin, the great Sanhedrin, because that where it says specifically in the Torah that Hashem tells Moshe to gather 70 people. So Bishar Beidina Mishamat Le. Well, second, what about other cases? Have you heard Rabbi Yehuda say that it's okay to have fewer? Now, it's interesting here because actually they should answer based on Ken's question. Yes, we have heard, because Rabbi Yehuda is the one who said that you can use 10 judges for a case of estimation. Now, I think that they will know that that case also is based on a pasuk, and so as a result, maybe that's why they don't reference it. But in any event, I note the fact that Ken's question from yesterday, could be arguably an answer to this. But v'chitema lo shna. So, but the bottom line is that we don't have a statement of Rebbe Yehuda by a smaller court, other than possibly the 10 judges that we mentioned just now, of a case where he says that an even number is okay. And if you want to tell me that maybe Rebbe Yehuda does not differentiate between the Sanhedrin and other courts and says that you can have an even number in other courts, Vatanan, we have the following in our Mishnah, where it says Smichas Zakanim Ba'arifas Egla B'Shlosha, that you need 3 judges in order to do the leaning on the of the elders on the bull of the par shalom davar, of when a court makes a mistake, va'arifas egla, and also for the situation of the decapitation of the calf when you find a murdered victim in the on the road and you don't know who did it. Divrei Rabbi Shimon, Rabbi Yehuda Omer b'chamisha, and Rabbi Yehuda says you need 5. Now, how come do you need 5? V'amrin, and my time of the Rabbi Yehuda. Now, this is not part of our Mishnah, but this is explaining our Mishnah. Why do you need it? The samchu, because the word samchu, in connection with the leaning of the judges in the Par Shalom Davar, it refers to shnayim, refers to 2. Ziknei, shnayim, and elders also refers to 2. Ve'ain based in shakel, and you can't have an even court. So here we have even Rabbi Yehuda, who says you can have 70, says you can't have an even court. So Mosif and Alei and Odechad Hare Kanhei, and so that's how you end up with 5. So that shows that you need that Rabbi Yehuda does not say that you can have even judges in other situations. So the Rabbi Yoshia adifam of the Rabbi Yehuda. Well, we can say that Rabbi Yoshia, who himself, is taking a stronger position than Rabbi Yehuda. Because when it comes to Rabbi Yehuda, he only thinks that the Sanhedrin is where you don't have a requirement for an odd number. But other cases you would. For Rabbi Yoshia, but when it comes to Rabbi Yoshia, you would, you do not require to have an odd number with respect to other courts. Velahai lintos my avidle. So one second. So what about the teaching of Rabbi Eliezer, the son of Rabbi Yossi Glili, who said that the whole point of the Torah saying lintos acharei rabim lahatos, that we need to decide based on the majority, that it shows that we need to have an odd number of judges. So mokim le la bedine nefashos. So that is specifically for cases of life and death. So if we take a look in Rashi, the Rashi is about midway down in the narrow lines, Bedine Nefashos, end of the line, Shetitkayim bo hatiatcha l'tova al pi echad, that we say specifically in that pasuk that we should decide for the good based on a majority of one. As we saw in our Mishnah, but if you have an even number, there's no way to have a majority that's less than two. So as a result, we need to have a majority of one in Dinei Nefashos cases. But actually, maybe not. Maybe we don't need that in monetary cases. So one second, so now we're going to challenge Rabbi Yoshia further. Elahad Tanan, but 1 second. What about the following Mishnah? This is a Mishnah on Daf Chaf Tet Amud Aleph. Sorry, let me scroll to get to that language. Okay. And now we're at the last question on the screen. Elahad Tanan Shnaim Omrim Zakai ve'echad Omer Chayev. Zakai, this goes to the question that Stan asked, that if you have two that say liable and one that says not, two that say he's not liable, that he's meritorious, and one that says he's liable, Zakai, the end result is that he's not liable. He's meritorious. Shnayim omrim chayev ve'echad omer zakai. If you have two that say he's liable and one says that he's meritorious, that he's not liable, chayav, he's liable. So nema delok Rabbi Yoshia. Should we say that this Mishnah is not like Rabbi Yoshia? And Rashi explains, De'ik Rabbi Yoshia, again, smack in the middle, just down the continuation from the last Rashi that we looked at, again, almost just below the midline of the narrow lines in Rashi. Lema Delog Rabbi Yoshia, De'ik Rabbi Yoshia, if it was like Rabbi Yoshia, that other Mishnah, Kevan Deshlishi Mikra Yelef, since the third judge is required from the Torah, Yelef Lahu, the Lav Mishum Nota, and not because we need a majority, maybe you need unanimity. Maybe you need unanimity. Right. So, El Afilu Tema Rabbi Yoshia. No, actually, even Rabbi Yoshia could argue that maybe you don't need unanimity. And we can learn it from a kal v'chomer, from capital cases, from cases of life and death. That when it comes to a death penalty case, which is very, very severe and very, very strong, and yet the Torah tells us that we follow the majority of even one. So certainly we should follow the majority when it comes to monetary cases. And so now we've actually come to the conclusion. So far, it seems that everyone agrees that monetary cases only require only 3 judges. But stay tuned for tomorrow's daf, because we're going to see that not everyone agrees that 3 is enough. Shabbat shalom. Have a wonderful, wonderful day. Looking forward to continuing our learning together.
Absolutely.